Oh, okay, cool. Awesome. Thank you.
It is, it is. Time is it? There's Brian. It's 6 o'clock. We'd all rise for the prayer followed by the Pledge of Allegiance.
Let us pray. Gracious God, we ask your blessing to be with us tonight in this city council meeting. We pray that you will bless our mayor and city council members and all those who have gathered to share in this meeting, that through discussion and decisions your will may be done. Pray your blessing upon our community. Pray for safety and well-being of all, especially those that serve and protect. And we remember especially, oh God, those who are fighting for their freedom in this world. And we pray that you will be with them and that you will keep them safe and that you will bless us as we support and encourage them in their freedom. And we pray that your will may be done for them, for us, for this world. For it is in your holy name we humbly pray. Amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Claudette, you are first on the docket. Come on up to the mic if you would.
Well, thanks for letting me be here tonight. I'm Claudette Patton, and I am running for district judge in Jefferson County Division 15. It's a county-wide seat, so the division number doesn't mean anything. If you see my name on the ballot, check off Patton. And I'll be on the back side of the ballot, second page, third from the bottom. So turn it over first and vote for me first, and then you can go back and vote for all the big ones. I want to be that judge that sees everyday people that come in for the first time to court, traffic ticket, probate court, might have a small claims court, and especially our juvenile justice. I want to bring juvenile reform to our criminal system, take care of our kids, so that they have the consequences that might be derived from their actions, but they don't lose their education piece and they don't lose school. And so I want to use all those resources to connect together and be in district court. That's why I chose district court. So thank you for letting me be here tonight. It's a pleasure and an honor. And don't forget, May 17th, vote for Patton.
Thank you. This will be the one time that the mayor will overrule a judge. Please vote for the mayor on the front of the ballot first. Then you can go back to vote for the other mayors and the judge. Reading of the, for those who have signed up for the item number 9, we're holding your comment period until that time. So it's during the event. If you also, unless you want to get up right now, but it'd be better to do it during the event. So we are going to move on to the reading of the minutes, February 15th, 2022.
Mayor, I would move that the minutes be approved as distributed.
Second.
Any discussion, corrections, or deletions? Hearing none, all in favor, please say aye.
Aye.
Opposed, like sign. Motion carries unanimous. General Fund Warrant 1556.
I move general fund warrant number 1556 be approved as distributed, please.
Second.
Any discussion, deletions, questions? Hearing none, all in favor, please say aye.
Aye.
Opposed, like sign. Motion carries unanimous. Road fund warrant 943.
Make a motion for approval of general fund warrant 943 as distributed.
Second.
Any discussion? Hearing none. Somebody say something? Road fund warrant 943.
I'm sorry.
Sorry. As corrected. Hearing none, all in favor, please say aye.
Aye.
Opposed, like sign, motion carries. First reading, Resolution 689, Series 2023. This is to put in contract our workings with Tech Plus that we have worked with over time. I will let Carson come to the mic and explain it, and then Skylar can go farther if you need to as far as how the contract is written. Or Carson, go ahead.
Actually, nothing like the contract outlines is different than what we currently do and have been doing for 12 years. The only big difference is kind of getting pushed from Microsoft and the software agents that we use to support you all. So we're a managed service provider, which means we provide you parts, labor, and software as a combination. Make sure that we monitor and manage the network. And the licenses that we resell to do that, starting July, require 12-month and 24-month commitments from us. So it used to be month to month. So if you added 2 licenses, we could charge you more the next month, or if you deleted some, we could charge you less. But now they're tying us into 1 and 2 year contracts for those. So that's what is pushing the contract. So I need a commitment from you all, so I can go back to my vendors and make a commitment to theirs. So that's really about the only thing that's changing.
You want to talk about the during the pandemic, the reason to how to get hardware?
Well, obviously with everything, hardware has been
And
very
pricing.
hard to get by, and pricing and everything else. But we have been able to go to our vendors, and since you are a government entity and lock in government pricing, it helps with availability a little bit, but really it's more just with pricing through pandemic.
Skylar, you want to talk to them?
The contract, which you have before you, very briefly, the bulk of it, really from about Article 5 or Article 4, Article 5, I should say, is pretty much boilerplate that we see in all of our contracts. These are terms that we insert in all of ours. The key points in this contract from the city's perspective, during the pandemic, the need for reliable, timely IT service was profound and very challenging. Tech Plus did an extraordinarily good job for us throughout that. Then, of course, came the supply chain issues and acquiring hardware, acquiring even software at times was problematic. And so we wanted to make certain that we had a solidified working relationship with Tech Plus from the standpoint of maintaining both our software and our hardware infrastructure within the city. And it's much more complicated than we might think because it goes in numerous different buildings, and it goes from telephones to laptops to security cameras to sensor systems. And so it's a lot of moving pieces. And so we were able to do that. That is outlined in paragraph 2. The other challenge that we had to be cognizant of was making certain that our hardware purchases conformed with 45A of the Kentucky Revised Statutes dealing with governmental purchasing, which we were able to accomplish in this agreement, so that if we encounter a potential purchase down the line, which may invoke 45A, the city has the ability to do that, working with Tech Plus as our contractor to either use approved governmental sources or to put it out for bid. So given the breadth of knowledge that Tech Plus had with this, we felt that that was viable. We also made it for a 2-year term with renewals, which is what we typically do. But I would add to that the one additional aspect of that was that looking forward, we wanted to be sure that we had this contract in place during the time when we see that there may well be supply chain issues continuing for that period of 2 years. I wish they'd be resolved tomorrow, but to protect the public, to protect the residents, the city, we felt that a 2-year term was critical in that regard. That's about all I have on it. Are there any questions?
We did run into, and Carson, I'll let you go farther than what I'm going to say. During the pandemic, when a person other than Tech Plus would call for a product that we were needing, they would lock up the price. So that when Carson called, he couldn't get all the discounts and the lower pricing. So we actually were at a disadvantage because somebody else called the company and they said, we've already given that price out and we're guaranteeing that price. Isn't that correct?
That is correct. So a lot of our vendors, it's kind of first come, first serve when it comes to big deals. So if you're a vendor and you hear that you all might be purchasing 50 laptops, it's the first vendor that goes to the supplier and says, hey, this is my customer, I need special pricing. Having a contract in place would kind of eliminate that, because we could then say, no, by contract, they are our customer. We have that relationship. So it stops other vendors from locking out that pricing. Because we ran into that a couple of times in the police department. They were buying equipment and another vendor had just heard that it might happen and they locked out our pricing on us. So, I mean, we were ultimately able to get it down, but, you know, it comes out of our profits. It comes down to negotiations. It just gets to be a big mess to try to get it to where you're comparable.
So it also, the contract allows him to buy it, as he said, at the state prices with a percentage on top, and the percentage is already set and it's there. Any questions, as Schuyler mentioned? I'll entertain a motion.
So moved.
Second.
Title only.
By title only.
Thank you. Second by Mark. Any further discussion or any discussion? Hearing none, all in favor, please say aye.
Aye.
Opposed, like sign. Motion carries unanimous.
Resolution number 689, Series 2022, a resolution authorizing the mayor to execute a contract with Technology Plus to provide information technology services. That concludes first reading. You may entertain a motion to approve.
So moved.
Second.
All in favor, please say aye.
Aye.
Opposed, motion carries unanimous. Thank you. First reading of Resolution 690, Series 2022. Dina, this is a resolution allowing the mayor to sign a lease with the chamber. Since Dina has come, she has been trying to make everything up to the standards that she is so used to doing. And she's also looking to the future of everything that's coming forth, changing and doing things all the way around. And many times people don't realize that the chamber building, yes, it is provided to the chamber, but the chamber provides a lot of service to the city. When I travel the state, I can tell you a lot of people know that the Gaslight Festival. So we're known, and it is a pleasing thing that they make us the hallmark community they do by providing the services through the Gaslight Festival that would cost us a huge amount because all the volunteer hours and your staff that puts it on. I very much appreciate that. So as we did the lease, whether it's the Gaslight Festival, which is the biggest, the fifth largest festival in this area, or the Beer Fest or other items that draw people to us, we look to the future of working with them and them providing the economic engine and also the services of the events that we don't put on, that we don't have to pay for. And I'll let Dina go farther with what you would like to tell us.
Thank you, Mayor, and thanks to all of you for giving me a couple of minutes. I appreciate those of you who could also join us last night for our annual meeting. Hopefully you had a good time. A little bit of this might be a repeat from last night, but as you know, we're the Chamber of Commerce. We represent about 1,100 businesses, over 30,000 employees are in that body of businesses across every major industry in our metropolitan region. So we are the third largest chamber in this region, so that's something for all of us to be proud of. We have a number of initiatives underway supporting our economic development and the work that the city is doing. And we do a lot of branding for the city because of the festivals and the things that we're managing and the businesses that we're partnering with. So we really feel like we extend that brand, the Jeffersontown brand, beyond just the borders of our city, which is good for all of us. It's good for our economy. It makes our residents feel proud about where they live. And like the mayor said, we do two main festivals in the J-Town community that really have an economic impact on our economy. One being the Beer Fest that we do in the summer. I think this is the 7th year for it. And we had a record crowd last year with over 2,500 here on a weekend night. And then everyone's familiar with the Gaslight Festival. So this year will be our 53rd Gaslight Festival. We put on 13 events. We've added events just in the last 2 years. So we do 13 events in 8 days. And we have an estimate of about 200,000 people visit our city within that 8 days. So it's an important part of the Jeffersontown brand, and it really contributes to the economy in a lot of different ways and supports our businesses, specifically in our town square here. So it is an honor to do that, and it is an honor to partner with the city. We could not do that event without the partnership that we have with the city and the resources that you put into it as well. So it's our privilege, Mayor, to be with you.
Thank you. Any questions?
No, you've been there a long time. We want you to stay.
I'm coming
Dina
up on my
has
2-year
But
anniversary.
the chamber has.
Don't call Dina old.
You mean in the building, yes.
The building has been here a long
Yes.
time. I can remember seeing Daniel on his ladder up there working on it
Bye.
years ago.
Well, that building has been used for many things. It was a fire department originally. It was used to hold the council meetings that you're having here. It was there to hold court in that building. In fact, at one time, Stanley Searcy was one of our judges, and he scheduled court the same time as a council meeting. By the way, you all went out. You all got the inside the building. He had to go outside underneath the tree. So that building has been well used, and now it is being repurposed for the chamber for many years. Any questions? I'll entertain a motion to approve resolution
Second.
by title only. Vince, thank you. We have a second by Mark. Any discussion?
No.
Hearing none. All in favor, please say aye.
Aye.
Opposed, like sign.
Resolution number 690, Series 2022, a resolution authorizing the mayor to execute a lease with Jeffersontown Chamber of Commerce. That concludes first reading. You may entertain a motion to approve.
So moved.
Second.
All in favor, please say aye.
Um,
Opposed, like sign. Motion carries unanimous. For those who are here under the last two resolutions or the person that's running for office that may have to hit other places, we appreciate you staying for the whole evening. But if you have other places to go or you would like to leave at any time, that would be fine. It doesn't hurt our feelings. First reading of Resolution 691, Series 2022. To let you know how this will proceed, Steve will present the person that is here to represent the person asking for the resolution will present, and then any opposition that we have signed up will be able to say what they would like to at that time. And then after that, the person that's presenting will be able to answer the questions or rebuttal at that time. Steve, if you would please.
Yeah, this is a resolution.
Hey, Steve, pull the mic closer to you. Thanks.
This is a resolution requesting approval of a amendment to binding elements. There are two actual zoning cases involved that the amendments are requested for. One is a zoning case from 1993. Which requests amendments to binding element 5A and 20, which deals with restaurants having drive-through windows as part of the operation. And then docket number 9399 had two binding elements, 11, again, pretty much same language. Restaurants with drive-through windows were not allowed, as well as the C2 uses restaurants with drive-through windows. So the three lots that are outlined in blue are where the requests are. The top one is Chili's. The middle one used to be Mimi's, and my understanding is that's going to be a Connor's Steakhouse or Steak and Seafood. And of course, the bottom one is Carrabba's. The properties are Zone C2, and they are in suburban marketplace corridor. Now, Planning Commission had a long hearing on this, and they actually made a recommendation of denial of the changes by a 5-4 vote. So that's any questions on that. I'm really kind of the conduit here. We don't really involved in, because there's no plan review with this. It's just an amendment to the binding elements. So they would have to come back to revise the development plan to even put a drive-through window on either any of the existing buildings or any future buildings. So,
Steve, can you answer questions after we hear the other people?
oh, sure.
Well, I had a question for Steve, just to make sure I understand the process. The C2 typically allows drive-through, but when this was zoned, the binding elements were added to not have drive-through,
So,
right?
yes, the binding elements were placed to prevent fast food restaurants with drive-throughs, is my understanding.
And that was in 93?
93 on the one, and I think the other one was in 1999.
Okay.
That was
So
for
over
the
20 years.
Carrabba's.
Okay. All right. Thank you.
It was what year?
93 and 99.
Thanks, Steve.
You're welcome.
John, you want to present that?
John Talbot. Do I need to give my name and address?
His name and company. That's all.
John Talbot with Barden, Werper, Talbot, and Roberts. Mayor, fellow council members, thank you so much for giving me some time. First of all, the binding elements are a little bit confusing. The way they were presented by Mr. Rusi, I think there actually is a couple things that might have been that probably were a little bit off. So if anybody wants me to clarify that, I can when we get to the technical description of them. But basically, he described it, the issue is to get rid of the binding element on drive-through windows. My opening statement on this case is these are binding elements that have been around for nearly 30 years. The time for these binding elements, they served a purpose at the time. That time has now passed. The second point is that this gentleman, Mr. Thurman, has these restaurant properties. Just across the street, you have a Skyline Chili. Not far down the road, you've got a Panera Bread, all with drive-throughs. Is at a significant competitive disadvantage as a result of these binding elements. And what my slide presentations will show, they really truly have no legitimate purpose at all anymore. They did in the 1990s, they don't anymore. The fact is a lot of things have changed in 25, 30 years. We didn't carry around cell phones and have our office and our desk. We didn't do virtual meetings. There's lots of things that have changed significantly. Mr. Thurman, when he tried during the COVID pandemic, when it was in its most severe time, restaurants were severely hard hit. He lost some tenants and could not get them rented out. Currently, he has them rented out. He was able to get tenants in them now. So one question may be, well, why are you here, John? In that process, it cost him about $350,000. It was very difficult. We'd gone very far down the road, and he does not want to go through that process again. But Mr. Rusi correctly pointed out, if you will amend these binding elements, it does not mean that he can put in a drive-through window without asking permission, without getting any approval at all. We will still have to get a revised plan that will be fully reviewed for code compliance and to make sure it works and works safely and appropriately if he does it. Removing these binding elements, all that it will do is put him on a fair playing field with the competitive properties around him. I mentioned a lot of things that have changed with 30 years. Hurstburn Parkway has changed significantly. A lot of things you all will remember that it used to be called Hurstburn Lane. I mean, I don't know if it was Hurstburn Lane at the time, but lots has changed on that road. These are the important points. The binding elements, they don't serve any purpose for the no drive-throughs. The vegetation that was put in to shield the residential properties, they were little tiny trees in the 1990s. They are very big, 70-foot tall, flush trees at this point. The properties are too far from the residents to really cause them any impact whatsoever. The drive-throughs are completely appropriate on Hurstburn Parkway, as you will well know just by driving down that road. It unfairly restricts these properties. As I mentioned, the revised development plan will still be required. He will still have to come forward again for an approval if those drive-throughs are put on. And most importantly, the Planning Commission staff recommended approval of this application. It did receive a recommendation of denial at the Planning Commission on a very slim vote of 4-5. The deciding vote on that case, by the way, spoke in favor of our application through the entire process. Why he voted against it then, I still don't know. I just simply do not know. But regardless, it was a very, very close vote. This is the zoning at C2, and I'm going to go very rapidly through these slides, by the way. This shows the aerial of where those restaurants are. I think everybody's familiar with the Chili's, the Mimi's, and the Carrabba's. You see the Lowe's and Republic Bank nearby. There's also the Gordon Food Service that has trucks coming in and out all the time. The traffic that might be generated if my client comes forward with a plan that will then have to be reviewed with a drive-through window, if he ever gets a tenant for that, would be relatively insignificant. This was some of the requirements for my client back in the 1990s. He was required to put in 201 evergreen trees, 54 flowering trees, and 27 shade trees. Again, those things were little twigs back in the 1990s. The impacts from having drive-throughs and fast food restaurants might have been significant then. They're not significant anymore. This shows the aerial from 1997. That's as far back that I can get. And the circled area you will see, that is the buffer where my client had to plant those 250 or so trees. This is those trees now. And if anyone's ever gone to Lowe's and looked that direction, you can see how large those trees are. They are thick, they are tall, and they are robust. Additionally, there is a fence that you'll see in some of the pictures that I'll show as well that goes the entire line. So that's the picture of the Lowe's that you can see that area. This is the distance as the crow flies from those restaurants. We've got 750 feet at the least, and this is to the closest house, not to all of the houses. 870 feet for Mimi's and over 800 feet for Chili's. The long way for impacts with all of those trees. In these slides, if you look closely, on the top left one, you can see the wall that's in addition to the trees. Most of these pictures were taken recently when the deciduous trees had lost their leaves. And even then, the blockage from those homes, I can't see a single window on a single one of those homes, even with the leaves off. When the leaves are on, it's even tougher to see through. This is the traffic. If you pull out of Willowhurst, if you look to the top, you can see where you would have to go. You go down Willowhurst, Stone Creek Drive, you go down Hurstburn Parkway, then you turn into the entrance of the Lowe's, and then you would go to those restaurants. And there's a couple other various ways, and to write all of those in it would be very confusing, but I think you'll get the idea. The traffic from what these restaurants might have, if my client loses a tenant, if he gets one that needs a drive-through, and if he gets it approved, is going to be completely insignificant. And you can see where the traffic light is on that one intersection. These are just some articles I'll go through very quick. I think everybody is well aware about the problems that COVID have caused for restaurants. It's changed a lot of things in terms of how we do business. We do Zoom meetings that we did not do. The restaurant business has changed significantly. Lots of restaurants, less formal sit-down restaurants, and even more formal ones want drive-throughs now that they did not want several years ago because people just got used to not coming inside. It's just a different market entirely. And I'm going through those very quickly again. You can look at them again, but I just don't want to spend a lot of time and just show you articles. Basically, it shows you what you already know. I hope you all will seriously consider changing these binding elements. It's been terribly damaging to my client. And the fact is the purpose of them existed in the 1990s. It does not exist now. Thank you all very much for your time and allowing me to speak.
I have a question.
Yes, ma'am.
Of the 3 parcels that you're talking about, right now they don't have, does Chili's, is it still in business? I don't even know.
Chili's is not in business anymore. There's a new restaurant coming in. They are not going to use a drive-through.
They don't want to drive through.
They do not.
Okay.
My client had several, in the period of time that he was out of lease, he had several people come, but the fact that the binding element was on the property, They didn't even talk too many further. And I'm not talking about McDonald's, but one of the things that's changed in the 30 years, there used to be McDonald's, there used to be really nice sit-down restaurants. Now there's a much larger expanse filling in that gap in the middle that are much more, they're not fast food like a White Castle, but they're also not a Vincenzo's, right? And they want to have a drive-through.
Okay. So then Mimi's is vacant. There's nothing there.
That's right.
Does he have plans for anything right now with a drive-through or no?
As far as I know, there are no plans for a drive-through. I think who he's currently running it to, Carrabba's, obviously they don't have one and they're not asking for one.
Not asking for
There's Mimi's and Chili's and no, they were not asking for a drive-through. The other restaurant next to that he sold because he tried to unload it to get some money. But again, I think on this slide, you might even be able to see the Skyline Chili across the street that obviously has a drive-through and the Panera's
Right.
down the road.
Right.
John, I got several questions.
Yes, sir.
Obviously, now Mr. Thurman owned the property originally.
Yeah, Mr. Thurman is the T and NTS, so he developed back in the 90s a lot of Hirschburn Parkway. So
Right.
he's been around a long time.
But if Mr. Thurman didn't have plans for drive-throughs, you wouldn't be here then, would you? I mean, because that's the only line item that you're wanting to change.
No, that's not correct. The reason, well, yes, he wanted to have drive-throughs. The difference was he did not want to have fast food restaurants. But there's a big expanse of restaurants nowadays that use drive-throughs. And the reason we're here is because when his properties were out of lease, he was having multiple potential tenants come to him. But the minute they saw that bonding element, they walked away.
No, and I understand that. A couple other things in regards to the property. You said that the traffic study would be relative. You didn't say anything about traffic study other than you said it would be relatively insignificant as far as an impact. Do you have that traffic study, or is that just a guess?
Well, that is my personal opinion, but Hirschburn Parkway is one of the most significant roads in Jefferson County. The amount of traffic that road generates for a restaurant difference would not.
I think it may be one top 5 in the state, but yeah.
In my opinion, it would be insignificant.
Let me ask you another thing. You said that the binding elements unfairly restrict these properties as far as competition across the street. Well, that's the city of Hurstbourne over there. This is the city of Jeffersontown. And then nearly 30 years ago, when Mr. Thurman agreed to those binding elements, he was fine with it then, and the residents were fine with it in Willowhurst and in Plainview. Now that he's wanting to move the goalpost, so to speak. So my question would be, if we change that, when else would he come to us wanting any of the other binding elements changed? Because there's a whole bunch of them. My concern is once you start changing binding elements that one party agreed to, and now, or both parties agreed to, and now one party doesn't like anymore, once you start pulling those pegs out, they're all going to start crumbling. So that's a concern of mine. I understand he may be at a disadvantage competitively across the street. Unfortunately, that's not really a concern of ours right now. Well, our concern has to be with the 30,000 residents here in J-Town.
Yeah, and I didn't mean to cut you off.
No, you didn't.
Yeah, obviously the 30,000 residents are important to you'll no question about it. That binding element was put in place to protect those residents of Willowhurst.
Right.
At the time, they had a perfect line of sight to look at these buildings. That's not true anymore. In 30 years, that condition has changed. I wouldn't say that we're asking for the goalpost to be moved. The conditions have changed. The market has changed. Lots of things have changed. And I think the request to change them is a very reasonable request. Now, in response to your thought that this could be basically a starting of a domino effect on the bonding elements, it's very expensive for him to take this through. I mean, we've been in this process now for a year. If he did these things one by one, trust me, if we had multiple binding elements he wanted to change, we would put them all together. So I think one request to change them in 30 years is not going to be the start of the domino. So that would be my comment to that.
Okay.
Is this binding element for
all
three buildings or for the whole area?
Just the 3 buildings.
3 buildings he
The
owns.
3 buildings. So it wouldn't affect that a little store, CFS or whatever it's called.
No.
Are those other 2 buildings, are they under long-term leases?
The restaurants, the other 2 buildings, or which one?
Chili's and whatever, are they under long-term
Over there,
leases
you
with this person?
That's a really good question. I got to be honest with you. I have not seen those leases, nor have I asked, but typically leases of that nature are pretty long term. I would think at a minimum of 5 years, and usually they have extension agreements attached to them. I mean, the investment that anybody puts in when they come in a new restaurant, they probably will put in a couple $1 million investment. So they wouldn't want them to be short. Usually the tenant would request that they be pretty long with extensions. So it's probably going to be a question if one of them goes out of business and has to move out, that would probably be what would cause one of them to come out. The odds of all three coming out at the same time anytime soon, I mean, I think is really unlikely. I can't predict it with a certainty, but I think it's very unlikely.
I had 2 questions. I think my first question would be, if there wasn't plans for a drive-through restaurant to be in, why is there a request to remove that binding element?
Yeah, I kind of addressed that, but there's so many things I mentioned in the beginning. When we started this process, he had his properties out of lease and he couldn't get them rented. And so that's when we started the process to put the drive-throughs in. In that process, and it was a long gap, it cost him he lost about $350,000 in that period of lost rent trying to get a tenant. And one of the questions that kept coming up or comments from potential tenants was, we need a drive-through and we don't want to have to go through a discretionary decision that we just are rolling the dice on whether or not we'll get. So they would go to another location. Fortunately, with enough time, he was able to get these tenants. Mr. Thurman does not want in 5 years, 10 years, 20 years, does not want to be in that same position again because of that binding element.
So just so I understand, this process started like a year and a half ago?
I think we filed
in the middle of COVID
last year, but I could be off a little bit, but it's been about a year.
About a year. And so when you say lost revenue, that was just potential loss, not actual loss, right?
Well, he had upkeep, maintenance, heating. There was a lot of actual out-of-pocket and lost revenue as well. And in terms of this process, I mean, hiring lawyers to do this, I mean, I'm not the most expensive, but I'm not cheap. And a year-long process with lawyers is not cheap. So it's not something he is wanting to go through again, that's for sure.
And then my second question is, if drive-throughs are put in, I'm just trying to think logistically how they would even work in these 3 properties. I don't feel like there's a lot of room there for a drive-through to happen.
That's an excellent question. And honestly, I think the Planning Commission was very confused about that very issue. If he has a tenant that wants a drive-through, they will have to make sure they can comply with all the regulations. Now, to do that, you need to hire an engineer. I have not done that, nor do I have the expertise. But if Carrabba's, for instance, because that's probably the smaller of the 3 lots, if they can't accommodate a drive-through, they can't have a drive-through because, as Mr. Rusi mentioned, if that occurred, that new tenant would have to get an engineer, get a development plan, come forward and go through the planning design services with a revised development plan, and then that would have to be heard and approved.
And I think I understand that. I'm trying to think, like, if I'm a restaurant owner and I want to bring a drive-through restaurant through, I'd want a spot where I can have a drive-through. And if I'm in the Carrabba's location, I can't have one go in. I don't know how that helps me by removing that binding element if I'm the owner of the property.
Like I say, we haven't analyzed because of the expense that would occur. And honestly, it would depend on whatever plan somebody came up with, whether they could do it. If it physically can't be done and meet the current regulations, we can't do it. So you all would remove the binding element, but there still could be no drive-through if it can't be done under current regulations.
Wouldn't that still put Mr. Thurman at a competitive disadvantage, in his words? If a drive-through can't go in, even if the binding element's removed, he still doesn't get those potential tenants.
Well, that would be a competitive disadvantage on the basis of his property. All properties have different advantages and disadvantages. He just doesn't want to have this legal shackle on him, right? Have the legal shackle on him, binding him, that's all.
Okay.
I have 2 questions also, please. I understand 30 years, business changes, business models change. Steak and Shake now is going to be a drive-through only, supposedly. People have had to change. But why is a drive-through so important here when the rest of those restaurants in that area do curbside service or pickup? They can park, walk in, get your food, and leave.
I'm not a restaurateur. I mean, in terms of Mr. Thurman, these are the 3 properties that he mainly has left. That was just the question that came up repeatedly.
Okay.
That the fact of not being able to have the drive-through was they wouldn't consider his property.
Well, I may have to go to counselor here, Steve. If we remove this binding element and you do come back with a development plan, if we don't have a restriction like this in there, we don't have a defense. Am I correct to say, well, we don't like that drive-through, that's got to go if the binding element is not here? Is that correct?
Not at all. Not at all. What is happening here is there is a binding element on the property that regardless of what is there, you can't have a drive-through window. So assume that that goes away and we're going to change Carrabba's into Sky's Fried Chicken with a drive-through. Okay. And if that were to occur, Sky's Fried Chicken would have to come in with a brand new detailed district development plan showing the revised layout, just like Bojangles would have had to have with the Steak and Shake property. Same thing. Have to show the drive-through, have to meet all the requirements for a drive-through. And at that point in time, the city council would give thumbs up or thumbs down to that particular design. What I hear is happening that with this impediment, for example, Sky's Fried Chicken wouldn't even take a look at this property because they've got to get this additional thing done before they do their revised detailed district development plan. And so it's easier to go someplace else. So the question before City Council tonight is simply to remove the absolute ban, if you will, on drive-through windows. And then if a development would come forward with a drive-through window, it would have to then come before the planning commission staff. It would have to come before our staff and then eventually to you.
Okay, well, thank you for that clarification, because I know that there have been some issues, zoning, redevelopment, all up in the air. You can't say no to that one because I understand. It passes all the binding elements and all the codes, and that's good to go. So that's what I wanted to clarify. Thank you.
You're welcome.
Right. I think none of us have been familiar with this at all. Does anybody know anything about this until just recently?
Since it came in our
I
packet.
did. An email on it.
I did not know that they wanted to do that. And I don't think you did, Pam.
No, just what came in our packet.
My question is I don't know, I guess I don't know what the issue is. We don't know what the issue is.
We're going
Okay.
to let the opposition say something.
Okay, then that might help us
If you want
because we
to.
don't know.
If John's going to sit down, I have one more question, John.
Yes, sir.
I'm sure Mr. Thurman's not interested in selling the properties. If the binding elements, if this council were to remove those binding elements, then Mr. Thurman could entertain those other companies that want to come in and lease from him. Even the big pocket, the deep pocket. Well, let's just assume whether he sold it or not. This is what I'm pointing getting to. So big pockets may bring in a type of restaurant that would want a drive-through and would have the money to raise that property and build what they wanted. That would meet our code of our codes and everything. So that's why I'm concerned about this. We have drive-throughs in Jeffersontown. I'm not being a stickler about that. I am a stickler on previous agreements that between residents and boards or councils, I should say, because the council and the boards set this up 30 years ago on this property. I have an issue with going back and changing that to benefit one side, not the other. I see no benefit, and maybe you can help me understand how it would benefit the residents in Willowhurst or Plainview.
Well, I probably can't satisfy you and say what we would do that would benefit them today and later. But The binding elements were put on there because those homes were built, they had a clear line of sight to those buildings. It was just there were no tree buffers there. And you could see it from that picture from 1997. Those trees are really big now. I mean, and it's not just one row of trees. It's a 70 or 80 foot wide berm full of trees. And so that is what has changed. And so I think it's reasonable for Mr. Thurman to ask for that change because it was put in for a reason to shield those neighbors. They don't need it anymore because the trees that developer was required to put in 25, 30 years ago have now blocked that view. And so it's a different situation. One thing I should also mention is that we are not asking that any restrictions on fast food restaurants be removed. That will still remain. So it'd have to be an upper, more high level type of restaurant. And maybe it's not Vincenzo's, maybe it's not Morton Steakhouse, but it would be a little bit higher level. If I could also follow up on one thing Mr. Alt said. First of all, it was all very well stated, and I just want to make sure this is clear in terms the clients that were looking at his property, Councilman Blum, that you were asking about. If they had the binding element, they could have a plan and request that be changed, but it would be totally discretionary. So they don't know whether it would be approved or not. If you get rid of the binding element, we would have to comply with the codes. And if they could build it, then yes, they could do it. But if we can't satisfy the codes, they would not be able to build it. And so, but at least there's some certainty there. A new tenant could look at the property and they could get their engineer. They could say, yeah, that can be put on that property, or no, it can't. So there wouldn't be uncertainty about whether they go forward. They would know and could do their due diligence and make an educated decision on it.
Why would this property be zoned C2 when C1 zoning has these restaurants?
I've got to be honest with you. I have not gone and reread every line of the plans from 30 years ago. I hate to tell you I can't answer, but I honestly don't know why it was zoned C2 at the time. I just don't know. It was part of a large general development plan at the time. I do know that. And then afterwards, you would have small portions that were set up as detailed district development plans.
Appreciate it, John. We'll probably bring you back up for rebuttal, possibly, unless everybody standing up says yes.
Thank you all very much for your time.
We'll go from there.
Mayor?
Yes.
Councilman Perkins, Powell, in answer to your question, the reason that, and I remember this from way back when, that it was going C2, the primary focus of the rezoning was to put in the Lowe's big box store, which required the C2. That's why they sought C2 way back when.
Thank you.
When was Lowe's put in there?
Long time. Yeah.
85?
No, 95.
So we will go from one attorney to another. Steve Porter, if you would like to get up.
Thank you, Mr. Mayor. Steve Porter. Live on Tucker Station Road. I'm not in J-Town, but I can look out my window and see J-Town. Look out the other direction, see Douglas Hills. Anyway, it's a pleasure to be here tonight. I hope you'll notice a blue and yellow for Ukraine. I want to make a couple of, just quickly before I get into the main presentation, Chili's is open. I think John got just a little bit confused. Mimi's has closed, and that's the new steakhouse that's going to come in there. But Chili's is open, Carrabba's is open. So 2 of the 3 are still old time. The old restaurants been around a while. And the 3rd one is a very nice steakhouse that's coming in. None
Steve,
of these
let me ask you something. Is Steve, the new steakhouse coming in, do they want a drive-through for
Not that I know
steakhouse?
of. I doubt it. I can't imagine a steakhouse with a drive-through.
Oh, me either. Throw me a T-bone. Okay.
So let me mention something. Let me
that's their
mention something to
slogan.
everybody that's going to speak. Just whoever speaks has, except for the presenter asking and requesting, gets 3 minutes. The exception to that is if a council person asks you a question, you get longer. So just Steve, you get longer. Special privilege.
I would like to have at least as much time as John had.
Okay.
I represent the Willowhurst Residents
Right.
Association, and with support from the Plainview Residents Association. And I'm going to point out one thing about changes in binding elements. The only people that can ask for a change in binding elements, besides a governmental agency, is the owner of the property. So when this agreement was reached between Plainview, Willowhurst, Hurstburn, Thurman, NTS back then, and these agreements were all reached, they were for the benefit of the residents, and that's quoted in the binding elements, that they are for the benefit of the surrounding area. But a change in binding elements cannot be initiated by Willowhurst or Plainview or even City of Hurstburn across the street, because that property is not in the City of Hurstburn. So it's a little bit of an unfair situation where the owner, Mr. Thurman, can come in and ask for a change in binding elements, but my clients couldn't do that. If there was something really bad happening there and they felt like, gee, we ought to get J-Town to make a change here, they can't do it. They don't have the power to initiate that. Maybe you all could initiate that, but they can't rely on the fact that that you would go along with that. So the original binding elements, as I said, were for the benefit, and with any changes had to be noticed to Willowhurst, to Plainview, and to Hurstburn. So it shows the importance of the neighbors. And I think John is wrong that the only reason these binding elements were put in was because the people on Willowhurst could see, or after a lot of trees growing up, could not see. What we're talking about is the whole character of this development, the whole character of this commercial development. And the character of that development is 3 or 4 or 5 restaurants, including Bonefish and now the new Gustavo's, gets it up to 5, and then McAllister's is in there too. Talking about, and none of these have drive-through or even asking for it, but the character of the restaurants is something that tells you about that neighborhood and about that location and about that commercial center. And by removing the drive-through without a good definition of fast food, it's just amazing. For 2 of these properties, they're taking out, there's still a prohibition for fast food. What is fast food? What is fast casual? What is in-house dining? What are, all these different phrases. This whole application, first of all, it's premature. And secondly, it's really poorly written and poorly thought out, because they took out the definition of fast food that was in there and didn't substitute anything for it. And it's our position that you need to have a definition of fast food if you're going to allow it or not allow it. And there's no definition for any of those 3 parcels that would remain after this is there. To me, fast food means you pull up to a menu board, you order 6 hamburgers, and you pull up to a window and they hand them to you in a sack and you pay for it. There's a difference between that and a drive-through window where you call ahead of time, or a pickup place where you park outside, and somebody like Carrabba's has a special place where you drive up and you've ordered on the internet, you've ordered on the phone in our good modern technology, and you get, you order ahead of time for a nice meal from Carrabba's. Obviously, Carrabba's, not by anybody's definition, is fast food, I don't think. And so they prepare it and they say, okay, in a half an hour or 45 minutes, it'll be ready. And you pull up there and then you call in and say, I'm out here. My name is Porter. Bring it out. And they bring it out and you've paid for it over the telephone or the internet. That is not fast food. But by taking out a definition of fast food, it leaves this in a real limbo. So I think this thing is poorly written from that standpoint. John said that there are restaurants right across the street that have drive-through. But if you go up and down Hurstburn along that stretch, say if you go all the way down to Bristol and then come up to this area, those are the only restaurants that have a drive-through window with a menu board. The rest of them don't have it. You know, the Bristol doesn't have it. The French restaurant, Brasserie Provence, doesn't have it. McAllister's doesn't. Gustavo's doesn't. None of the current restaurants on this property have drive-through with a menu board, and a number of them will have order ahead of time and come up, and that you can go in and pick it up, or they'll bring it out to you. But the difference is what kind of a restaurant has a drive-through window with a menu board. We're talking White Castle and KFC and McDonald's and hamburger places, whatever. And that is not the kind of restaurant that was anticipated in this property even 20 or 30 years ago, and it's not the kind of restaurant that the neighbors want to have and deserve. So by removing that definition of fast food, it really it doesn't clarify anything. It makes it even worse as to what's happening. So to preserve the character of these three parcels, we think that it should remain with that binding element. And if Mr. Thurman wants to come back someday down the line with a much better definition and a much better idea of what kind of restaurant should be at that location, then certainly you all could listen to that. But I think what has been proposed to you is not a good plan. It's poorly written. It takes away that definition. It just, as a matter of fact, for the Carrabba's parcel, it doesn't even prohibit fast food. It prohibits it on the other two parcels, but takes out the definition of fast food. It's just not a good thing. And the Planning Commission, it was a close vote, but the Planning Commission voted to deny this proposal. And a major reason for it was the possibility of what's going to happen with traffic in that whole area. We don't think that just because there are trees separating Willowhurst from this area, that is the only reason that binding element was put in there. It was put in there to protect the ambiance of that whole center. And that center has, for 30 years, had sit-down quality restaurants, and that's what the neighbors want.
Thanks, Steve.
With that, I'll take any questions.
Yeah, Scott.
No question?
Scott.
Steve, for purposes of the record, if this change were to be made, what would be the impact on your client specifically? Because I haven't heard that, and there's nothing showing any impact on your client as opposed to the land in front of them. How would this change your client?
Well, Willowhurst is part of that whole development.
Yes.
That whole development included Willowhurst.
But it is buffered.
It is their center, their neighborhood.
When this binding element came in, there wasn't a Lowe's buffering them from these three parcels of property. And my concern is unless there is a nexus to the residential properties you represent in terms of negative impact, how is the council not acting arbitrarily and capriciously in denying this request? That's the question I need you to answer for me.
Well, the council would not be acting arbitrarily and capriciously, because the council would be supporting the agreement that was made when this whole development, including Willowhurst, including Lowe's, including these parcels, was all put together. And that original agreement was with agreement for everybody developing all of that. Willowhurst and Plainview area, which is part of it, right next door. And that was the agreement that was reached. And to remove this without any permission from Willowhurst or Plainview, I think it would be an arbitrary decision, because they don't agree to that. And there's no good reason to remove it. Now, you could go back, Skylar, on a million binding elements and say, Now that some trees have grown up, we don't need any more binding elements to plant more trees. We don't need any binding elements to do a lot of other things.
But Steve, I think you'll agree with me that one of the key elements of any sort of decision by city council on an issue such as this is if the person or entity that is opposing a change has no harm befalling them from the change and presents no evidence of that, then you're asking the council to make an arbitrary decision without any injury to the complainant. That's where I need you to provide something for us.
The injury is it could possibly change the whole ambiance of that whole center by removing sit-down, high-quality restaurants and allowing fast food restaurants with a menu board and outside speaker systems and noise and cars lined up in two lines, merging into one pickup. And that would be a major change in that. You know, and along those lines, Skylar, there are a lot of other things that are not permitted. There's a prohibition against bookbinding. It's not going to harm the people in Willowhurst. So you think they should remove bookbinding also? A bowling alley. Bowling alley was prohibited.
Thank you, Steve. You've answered my question.
There are a lot of other things in here, community buildings, a dance hall, a daycare center. Those would not, probably my clients might not be object to any of those. And so Mr. Thurman's not asking for any of those to be removed. He's just asking for this one thing to be removed, which would change the whole character of the neighborhood.
Thank you. Any other questions for Steve?
I have one question. Be careful what you wish for. You know, I can see. I'm gonna hear more of y'all's point of view here in a minute, I'm sure. But restaurants have to adapt to stay in business, and you can see the ones that weren't able to adapt, as opposed to like Chick-fil-A, who was very easily able to adapt, and so if they can't adapt, they might be sitting there empty no matter what. You know, you don't want an empty restaurant sitting out in front of your property either. So that's just one thought.
All right. Thanks. Thanks, Steve.
I think that's a good point, but, and John pointed out some things about the tough times that restaurants have had. Late article, and I think it was in Business First. More new restaurants have opened up in the last year than closed. I mean,
not the last 2 years.
Restaurant industry has always been a changing industry. It's a tough business. Restaurants closed before COVID. They closed because of COVID maybe, but new restaurants have opened up. And it's just a matter of what kind of restaurant do you want in your neighborhood on that particular commercial center. And the tradition here and the protection here was for 3 quality sit-down restaurants without a menu board and an outside speaker system and cars lined up all down the outside.
Thank you.
Mayor, if I could say a few things, just as somewhat of an expert on this subject.
You want to wait?
How many more speakers do we have?
Whatever you want to do.
I don't know, but I've been waiting to speak.
Go ahead.
You
What you want to wait till everybody presents, or do you want to do it now? Your choice.
Or both.
I think the reason I'm going to interject now, because I may abstain just because of a conflict of interest. I have been in the restaurant business for the last 30 years. And I can tell you what Vince told you, they absolutely changed a lot. I really don't see how it's going to impact the citizens because of the Lowe's behind it. I think it's a whole lot of traffic. At the same time, I don't think the other guys is negatively affected either. All 3 businesses are leased.
Mm-hmm.
So I don't really see, I think he did have a loss of about $350,000 while it was empty, but right now he's at no loss. They're all leased. So I guess what I'm saying is there's no harm, no foul. Neither side has been harmed at this time. And I don't know that we should change it because of that. But like Vince says, be careful because you may get empty buildings up there and you don't want empty buildings.
Thank you. Thanks, Steve.
Thank you all.
I'm trying to read right. Is it Bruce Youngman? Yeah, let the accountants talk last.
Thank you.
Mr. Mayor and ladies and gentlemen of the council, I can shed a little light on some of the representations that have been made by the developer. My name is Bruce Youngman. It's been almost 25 years since I've been part of this group, and I'm very happy to be back. I think Carol's the only one.
Yeah, I was gonna say, I think Carol's the only one.
Now, it was ringing a bell.
Yeah,
Were you with Arthur and Son or something? Something? I didn't know
You
you.
look the same, but anyways, that's
Yeah.
Just a few things. I was the first president of Plainview Residents Association after it was annexed by Jeffersontown. I was chairman of the Jeffersontown Civil Service Commission until I was, let's say, early retired by Danny Ruckriegel over a disagreement. I've been a resident of Plainview for 45 years. I have represented Plainview residents in several zoning issues, including this one. I don't know if John, if that's his name, if he was out of law school when we argued that and put in binding elements back then in the 90s. I helped negotiate the binding elements, and the problems and the issues of Willowhurst was just one. Plainview had objections, and we wanted to, as Mr. Porter said, we wanted to keep it as an upscale environment. Mr. Thurman flew some of us on his private jet to Memphis, Tennessee, to show us how beautiful this was going to be. And there were going to be upscale restaurants, and he started off on the right foot, and that's what he did. But now, I guess things have changed. Last Wednesday, in the Wall Street Journal, there was a article on property. Drive-through demand heats up. That's why we're here. We're here because of that. Has to do with money and money for the developer. And I don't see how finding a nexus, as this gentleman suggested, on how it hurts those of us who negotiated the binding elements 27 years ago, it should be discounted. I submitted a memorandum, it would be in your package, I guess, to the Planning Commission, and I just want to very quickly just highlight a couple of them. The developer admits that the reason for these amendments is to enhance the marketability. The developer, after negotiation, committed to these binding elements 27 years ago. There were drive-through restaurants 27 years ago. The staff report said the binding elements are for the benefit of the surrounding areas. That's their quote. For the benefit of the surrounding areas, not the developer. One of the surrounding areas is Plainview. As I mentioned, we negotiated those changes, those binding elements. The drive-throughs did exist 27 years ago, and we were well aware of it. Developer's attorney states in one of his letters, that's part of the record, quote, the binding elements were, quote, to restrict the use of drive-throughs which are intended to prohibit fast food style restaurants, close quote. He argues this truth should now be ignored. Drive-throughs at these existing restaurant locations would reflect the recent changes in the restaurant industry during the COVID pandemic, he says.
A once in a lifetime pandemic, ladies and gentlemen, is no reason to change zoning laws. And the restaurants that involved, they're not even requesting it. The reference letter that I mentioned from the developer's attorney says, quote, "To-go orders have become essential to the survival of many restaurants," close quote. There's no evidence that this statement is true for the restaurants involved in this case. And if it does apply, as was mentioned, all of these restaurants, I think all of them, have to go. Call, pick up your food, and they still have that service. And we're fine with that. We were fine with it then, we're fine with it now. None of the restaurants have, to my knowledge, are requesting any of this. It's all about the developer. It's not about the residents. The developer in another letter says, quote, "We believe that 27 years, and you heard it again tonight, is enough time for purpose of the binding elements at issue," close quote. That's quite noteworthy. Apparently, it's enough time to benefit the surrounding neighbors, not enough time to benefit the developer. He wants to change. He says, that was 27 years ago. Well, the pandemic is over. The drive-throughs, if it was approved by this body, will remain in perpetuity. And there'll be more changes after that. For those, I'm not on retainer to anyone in Plainview, but I can tell you that we would cordially and respectfully request this council to reject this request for amendments. Thank you.
Thanks, Bruce.
Thank you.
Barbara, you're next. I'm doing them in the order that they're in here, nothing in particular.
What was his last name?
Thank you. I appreciate this opportunity to address the council. I am not.
Barbara, pull the mic down.
Just a little bit, Barbara.
Thank you.
I appreciate this opportunity to address the council. My name is Barbara Ritchie. I am a 32-year resident of Plainview subdivision. I am not an attorney. And I appreciate just the opportunity to tell you as a resident why I'm opposed to amending the binding element. In my opinion, it's just not necessary. Period. It is not necessary. These restaurants, including Carrabba's, Chili's, and the new restaurant that is replacing Mimi's Cafe, which I believe is going to be something called a Connor's Steakhouse, they are not fast food restaurants. They have no need to be. The once vacant Mimi's Cafe has been leased, and this new restaurant, to my understanding, will be a sit-down restaurant, which is being erected currently. If drive-throughs were added to this already busy commercial area, in my opinion, traffic studies would need to be done regarding the impact on Hurstburn Lane traffic. All of these restaurants serve alcohol. How would drive-throughs be handled? How would alcohol be handled at a drive-through window? I don't know. I doubt these long-term tenant restaurants want to build or operate drive-through operations. They are sit-down restaurants. They're thriving. They have no need for drive-throughs, and I don't see them as wanting them. Drive-throughs require certain things. Menu boards, usually large, lighting, very bright, speakers, etc., and they would be a nuisance, very frankly. Again, completely unnecessary and would detract from the ambiance and the character of our neighborhood. I appreciate your consideration.
Barbara, Barbara, you omitted, you didn't tell us, you are in your second term as the Plainview Residents Homeowners Association president, correct?
Yes, sir, I am.
You oversee about 1,200 homes, about 4,000 people. Of those 4,000, has anyone sent you a text, email, or verbally told you they're in favor of this?
No.
Okay.
Actually, we sent out a postcard about this issue, and we got no, Madonna, we didn't get any positive response that people wanted. We did not, out of all of our residents.
How about negative responses?
No.
Didn't get
We
any?
got no response, basically.
Now, she's referring to Madonna Burke, who's also the Plainview Residents Association administrator and has been for well over 20 years.
Yes. Thank you again for your consideration and allowing me to speak.
You have a question?
Barbara?
Yes.
Barbara?
Yes.
I have a question.
Yes.
But I don't know that you can answer. It might be an attorney's question. Barbara brought up something about serving liquor out of a drive-through window. I've never seen that.
It's legal now.
It is?
It's coming.
Yes, we actually started it in J-Town and it's passed state law.
Wow.
Because of COVID, Mayor, or something?
How do you monitor that? I don't,
Who serves it?
It has to be in a sealed container in order to.
Which this could be considered sealed.
No,
Has to be
that is not.
That is not.
That is not. It's got to be a factory sealed container. It's now in the liquor laws, was made permanent in the last legislature. If you were doing let me use a margarita because that was a real example we had to deal with. You can serve the margarita mix in a cup like that with the airline bottle of tequila that has the factory seal on it, and they can be put together and offered to go.
Obviously, I don't do that.
Actually, Skylar was the one that worked with the ABC during the pandemic to allow people in Jeffersontown restaurants be able to do that to survive because that's the only way they could serve food, and they were able to serve liquor. There's another mayor in another city that copied what we did, but that's okay. We won't mention his name.
He's leaving, right? He's leaving. He's
May I
leaving soon.
give an update. Madonna has informed me that there were responses to our postcard mailing to all the residents that went to the Louisville, Jefferson County Planning and Zoning. And all of those responses were against amending the binding element.
Okay. Thanks, Barbara.
Thank you.
John Beam.
Good evening, Mr. Mayor and Council. Appreciate you allowing me to speak this evening.
Can hear you, honey.
There you go.
I appreciate you allowing me to speak this evening. I am the president of the Willowhurst HOA and in opposition of the requested change to the binding elements. A lot of what has been said here is part of what I was going to tell you in our opposition to these binding elements. The one thing that we found is that these binding elements appear to be very well thought out and written. You can see all the details that are in there of what is or is not included, what is prohibited. And we felt that that was to establish a certain integrity and character for the commercial development for the benefit of the community. And even though it was mentioned that that was 30 years ago, fast food restaurants drive-through service was established in the late 40s, some 40, almost 50 years ago, before this development was put in place. And this has stood the test of time. To my knowledge, there are 0 vacancies, 100% occupancy there. We feel if this was allowed, the binding elements would change. It could affect the other tenants and property owners there that maybe they don't want to be in a community or in a commercial establishment that way, and they may vacate. So it could have that opposition. We don't want vacancies either. I mean, we understand that that is not in any way something that anyone wants. It would have a negative impact. But we think that this is very well thought out and that it has stood the test of time through recessions, other economic downturns, thank goodness, through the pandemic. We think because it is well thought out and the type of restaurants that are there, that it can continue to do that. It would be nice in a perfect world if something were for sale, that it was sold the following day and there were no losses for maintenance and upkeep. But whether it's commercial property or residential property, that is usually not the case. You can't put a timeline on how that's going to take place. And we're just fortunate enough that we do have full tenants in there and that it is a part of a viable community. And we feel that it's definitely because of the integrity and caliber of how this was established. There were opportunities then to put in fast food, drive-through service, but it was strictly prohibited to develop a different type of development. And it has stood the test of time. As far as the infrastructure that was mentioned, that was put in at the same time that these binding elements were created. And it was not to, at a later date, change things to allow things to be different. It was to enhance the overall development, is the way we feel in this matter. And we do appreciate your time. And if you have any questions, I'd be happy to answer.
John, what was your last name, sir?
Beam.
John. Did you say Joe or John?
I thought it was John. I said John.
John, okay.
John,
yeah,
I didn't get his last name. It's Beam. Okay.
Beam.
Thank
you.
you.
Appreciate it, John.
Thank you.
Ed Thompson. I guess I could have figured out the order and brought you on.
Good evening. Can you hear me?
Yep, you're good.
My name's Ed Thompson. I'm a resident at Willowhurst Place, 620. Been there for 27 years. And quite frankly, my knowledge of this is minimal. What we see with the binding elements and all that goes with it. And it's kind of a learning experience here tonight. But what I want to add is this, is that the potential of 3 fast food restaurants in that area on Hurstburn Lane is something that I cannot fathom. And that's a possibility. We're not talking about 1. We're not talking about 2. We're talking about 3. So I've listened to Mr. Talbot twice now. Listened to him at the city council, at the Jefferson Metro Council, and tonight. And he always refers back to Willowhurst Place. This is more than Willowhurst Place. We have Douglas Hills. We have the whole ambiance of everything that's around the neighborhoods. But he minimizes it by saying Willowhurst Place. Well, it's not a small thing to all of us, including you all. So when I look at this and I say to myself, how can we feel like that this is the right thing to do? Well, if it ever is the right thing to do, then I say 3 things need to be considered and looked at hard. And that is 1, pedestrian safety. If you put 3 fast food restaurants in there, you better be able to figure out how to move and move children around on bicycles and cars and everything else that goes with it. And 2, I think you better understand how to move cars in and out. And I'm not saying you won't, but I'm saying that you better consider it. And then the other thing is that Hurstburn Lane is a beautiful, beautiful place to travel. And you should and probably should consider the cleanliness of commercial and residential property if changes are made to these binding elements. So I stand here tonight to tell this board that I oppose any changes to the binding elements. And I hope it didn't take 3 minutes.
Thank you. You're good. Thanks, Ed.
Thank you.
Appreciate it.
I appreciate it.
Now for the better half, Julie Thompson. I'm not being biased. I don't know her. I just figured.
Oh, come on. Tell the truth now. No, I'm Julia Thompson, and I don't sit on the board at Willowhurst. But I do head up what we call the WOW group, which is the Women of Willowhurst. And I have been on that board for many years. And it has been brought up in the last meeting that I heard from the commission. Something that really hit my heart. And it almost was that We've got a nice little neighborhood up there that we don't want disturbed. We're not that kind of people at Willowhurst. We're a very diversified neighborhood. We have children 3 months old up to teenagers. We are a lovely neighborhood, and we thank you all for the things that you've done to help us keep it that way. But to say that we think we're too good for a fast food restaurant, that is absolutely the furthest thing from our minds. 80% of the people in Willowhurst are senior citizens, and that is quickly turning over. Just in the last month alone, people under the age of 40 have bought homes there. I've been there 27 years, and I've never had a neighbor I didn't like or didn't get along with. And as far as Mr. Thurman, Willowhurst Place doesn't have the money to come before this board and fight these binding elements like perhaps they do. We're just a little neighborhood up in the back that want to be protected. Coming down that hill from Willowhurst Place is very, very dangerous. We've had to remove plants because people don't stop at the stop sign. They come barreling through. That puts us at danger. You put in fast foods, children from Plainview are coming in on bicycles. Hirschburn are going to come in from bicycles. The young ones we have in Willowhurst are going to come in on bicycles. You can hardly see. Are you going to close that street there by Bonefish so that you can't cut through? There's no light there. There's no pedestrian crossings there. I just think changing these binding elements at a time when we don't have a valid reason to do so, for Plainview, we got 105 new apartments coming in at the very end of where Willowhurst residents come in and go out that NTS have gotten through. The last time I was here was on those apartments. 105. If each one of those have one cars, they'll be millennials, they'll have two. You're talking anywhere from 150 to 170 cars right on that one street coming in and out. And the biggest argument that evening was, how are they going to get in and how are they going to get out? And now we're talking fast food. Willowhurst isn't too good for fast food. We got a great group of people. We just want it to be safe. And I can't see how changing the bylaws or the binding elements is going to make it safe as it is now. I thank you so much for your time.
Thank you, Julie.
Thank you.
Julie, you might want to know that I don't think those apartments are coming in.
Oh.
Well, the costs have gone up dramatically.
Well, thank you.
So.
No, they're still able to come in. There's other reasons they're not coming at this time. Okay. Thank you. Nikki.
Good evening. Can you hear me?
Yes.
Okay. I'm Nikki Eager, and I also serve on the Willowhurst board. And I'm not going to take too much time because I feel like my neighbors have done an excellent job of portraying our concerns. But the main thing I want to hit on is our number one concern when we heard about this and potential for fast food, which really is drive-through service. And the frequency, the amount of traffic that comes in is the traffic, and all that brings to our neighborhood. And that is the main reason that the city commission overall denied it, was concern over traffic. You've got, as Julia said, coming in and out of our neighborhood is the access point to get in. So many people from other neighborhoods cut through there to do that. With the frequency of drive-throughs, as Ed said, it could be potentially one, but you're opening it up to all three. Should all three of those be converted, then it's just going to increase the traffic, not only on within, the surrounding area, but especially on Hirschborn Lane and Hirschborn Parkway as it is now. It was a lane before, and I think the people that were there that agreed to these binding elements were the ones that had the forethought to think, how would this potentially impact the neighborhood as, should there be drive-through restaurants there? And that was the one thing they put in to protect us. And as you know, Hirschborn Lane is Parkway, and it is already crazy going in and out. Even with us exiting on Stone Creek Parkway to try and get on to Hirschborn, it becomes, a lot of times a matter of waiting on both lights and 2 or 3 minutes just sitting there, which, we love our neighborhood, we do it, but I can't imagine what that would potentially do to the neighborhood and getting in and out, and just how, it does affect us overall, that traffic component does. So I think that's just the one thing, in addition to the idling, the potential with pollution, the noise factors, it's all of those things combined that would potentially affect us and why we have our concerns.
Thank you, Nick.
Thank you.
Thanks.
John, do you want to come? Oh, watch the.
I do. Thank you very much for your time, and everybody that spoke. Thank you all as well. When this case first came to me, I thought it would be a really simple case, which has obviously not been the way it's been. What's really surprised me more than anything is how much confusion been on this case. The last woman who spoke, she mentioned that traffic was the main issue. That is certainly not my recollection. The main issue was there was confusion that people thought, the Planning Commission, that we would be able to do whatever we wanted without coming back through the process. And that was the main issue, and that was the reason we lost so many votes on my recollection. Tonight, I'm seeing a brand new misunderstanding. Nearly every person that came up in opposition has complained that they do not want fast food restaurants. We have no desire to put fast food restaurants. We have not asked for the binding elements on fast food restaurants to be removed. If you look back in this case, sometimes they said no fast food restaurants, sometimes they said no drive-throughs. It was clearly a shorthand back in the 1990s to mean fast food restaurants. Today, the way restaurants are run, the way the market is, a lot of restaurants that are not fast food have drive-throughs. It's just a different market environment 30 years later. If you look at the drive-throughs at Republic Bank, there are 3 drive-throughs there right next door. The problem has never been with drive-throughs. The problem has been with fast food restaurants. We are not asking for fast food restaurants to be allowed here. We are not asking for that to be removed from the binding elements. Mr. Porter mentioned the definition of fast food restaurants. We presented to Willowhurst a very detailed definition and offered it to them for fast food restaurants. They rejected it. That definition, I won't take you all through it unless you would like to hear it, but it included things such as no alcohol sales. Fast food restaurant does not sell alcohol. Nice restaurants do sell alcohol. Nothing else. That probably eliminates about every possible fast food. Included in that definition, we said no McDonald's, no Wendy's, no Burger King, no White Castle. We do not want fast food restaurants. We gave an example of ones that would be allowed. Panera, Starbucks, Piney Brothers. That's how we defined it. Could that definition be improved? Maybe. I don't know. When we presented that to Willowhurst residents, they flat out rejected it. We got no counter. We got no request to change. They simply said, no, we do not agree. We'll see you. We'll see you before the commission effectively. The last thing I want to mention is one of the gentlemen asked that I keep mentioning Willowhurst and not others. And I did think it's, I don't think I've heard my name, Mr. Talbot, said this many times since I was in trouble in 5th grade. But the reason that I have referred to Willowhurst is because in all of the binding elements, they refer to Willowhurst. They do not refer to Douglas Hills. They do not refer to Plainview. They do not refer to anyone else. That's not to say that those people don't have a right to speak and that they're unimportant. But at the time of those binding elements, it is clear that those binding elements were put in to protect Willowhurst. The only thing that differentiates Willowhurst from these other neighborhoods is the sight lines, and those problems no longer exist. So fast food is still in there. If there needs to be a definition, we are happy to propose one if you'd like to hear it. The fact is the industry defines fast food, so without a definition of the binding elements, it does still exist. And if we tried to bring in one that's clearly fast food, trust me, we would hear from Mr. Porter at the time we're going through with our revised plan. He would not shirk that. We would have to make it clear that it's not a fast food restaurant. And the bar is probably more difficult for us by not having a definition than the other way around. I know you all got a tough decision. It's late and you'll have listened to a lot. Thank you very much for your consideration.
you're asking for all three of these to be changed. Why couldn't we just leave it the way that it is and not change it? And then, if for some reason that you needed it, why could you not take one of those out of the three and come back to us and deal with just one and not all three? I mean, why are you doing all three?
That's a very good question. The process to go through a discretionary change is long and hard. We have been in this process for a year and the result is very indefinite. No restaurant that is not fast food but wants a drive-through wants to go through a year process and roll the dice on whether or not they will be approved. If we get rid of that binding element, we still cannot have fast food, but then the only decision is, do we meet the code requirements? And they'd say we can look at the attorneys, the engineers can look at the regulations and make a definitive decision that we can say, yes, if you check all these boxes and follow all of these regulations for traffic, for safety, if you can satisfy all of those things, you will get approved at that point. That is the difference. It becomes discretionary and it's a very long, hard fought process with no idea of whether you'll come out the other side and being allowed to do it.
But wouldn't you have to do that anyways if you're going to have a plan certain for like a drive-through to come in? I mean, if the binding element's removed and the property is sold and a new owner wants to put a drive-through restaurant in, they're going to have to come back here anyways.
Well, we would have the benefit that the zoning would permit it. We would not be in violation of any of the binding elements. And so we would still have to go through the revised process. And not to say that that's not hard, because it is hard, but it's not as hard as having the additional burden of this binding element. The binding element makes it significantly more difficult, time consuming, expensive, and most of all, a chance of whether or not you get through that.
I mean, I think it does become more difficult if you're trying to recruit a drive-through restaurant into a place that doesn't allow drive-through. That becomes difficult because you have to get rid of the binding element before you bring the drive-through in. I'm just trying to think like, you know, if going back to what Skylar had talked about earlier, if we remove it, it allows that like in the property sells or someone wants to come in and put in a drive-through, they're still going to have to go through it for a site certain, right, Skylar? And then they're coming to the review committees anyways, like, so it's still happening either way. It's just back to Carol's point, like why now versus if you've got somebody that wants to do that, bring it then, like, and just knock it out.
They've got 3 valid tenants. He's not at a loss at this point. I don't
see the need.
We got to be careful. Remember that apartments a few years ago, we didn't want to, nobody on this board wanted to put those apartments in, and we were told that we had to because they were within compliance of what was written. So if we change this, you know, if somebody comes in and wants to put that
Ties the
restaurant
hand
in,
later potentially.
we would have to put it in. So I don't know if we want to do that, you know.
Yeah.
Councilman Blunt, I mean, we do not want to have fast food. The drive-through restriction, just evident by the bank having the drive-throughs, has never been the issue. In my opinion, that was a shorthand for fast food restaurants because 30 years ago, you did not have this middle area of restaurants. You had nice ones and you had your McDonald's. That's all you had.
Well, I'm trying to think of, and I guess
The restaurant was like Cordoba, something like that.
That's what I'm trying to figure out is in the head, like what a nice restaurant is that has drive-through. Like to me, because again, I'm thinking even Qdoba to me is fast food, right? Like, I mean, I can order it and I can pick it up and I'm gone in less than 10 minutes. Right? Or really 5 minutes is ideal. So like, I'm just trying to think like, but if I've ordered from these sit down places, which I've done during the pandemic, and I go sit in their parking lot and wait, I usually order 30, 40, an hour ahead. Like, you know, you kind of know you're going to a different place. So
Councilman Perkins probably could speak with more authority than I can, but what I understand is that the restaurant industry has changed, and even sit-down restaurants some of them have asked for drive-throughs at this point.
Mm-hmm.
And again, with our definition that we had proposed, no alcohol, I mean, that would exclude all sorts of things. So you can't sell, if you don't sell alcohol, you can't even get approved. So that would eliminate a lot of issues with all of this. But we have never been trying to get, I tell you, we are not trying to get fast food restaurants on this property. We're not trying to change the character. We're trying to be in a position to adapt to a changing marketplace, changing environment, still have nice restaurants on that location.
Thank you.
Mayor, I'd like to call for a vote.
Thank you all.
You have several options. No, Steve, sorry, no, sorry, no, sorry, no.
Two things that were absolutely wrong.
Sorry. It's already been called for the vote. You have three options. One of them is to table, to allow the two sides to possibly have discussion to move it forward if that is so chose. And then if you have a vote to approve or a motion to deny, or actually you have the fourth option, if you do nothing, the motion that has been passed downtown would carry forth. So if you vote to approve, that would, Schuyler, would you explain what approval is? It approve the denial or is it approve the approval?
We always have this. The first motion that we make is to read the resolution by title only. Okay. And even if you vote yes for that, doesn't mean that you are voting yes on the substantive motion, which comes after that. Okay. So all that first one that we do to read it by title only is simply that I don't have to read word for word this entire resolution that's up there. I only have to read the title. If you remember, I'll say you may now entertain a motion to approve typically, but in this case it would be you may entertain a motion. The motion would then be motion to table, motion to deny, motion to approve. One of those.
Would you also explain if they did a motion to approve, if that's a motion, or Steve, either one of you, Steve, if you would explain if a motion to approve would make it a approval or a denial?
The resolution, as we usually do it, is the resolution is written in the affirmative. So it would be a resolution to approve the binding element amendments.
Yeah, if you'll notice down, now therefore be it resolved that the city of Jeffersontown does hereby approve the amendment to binding elements and is subject to the following binding elements to wit. And then it goes through.
So if you approve it, that means you're allowing for the item to be removed.
Correct.
Correct.
Okay. If you deny it, you allow it's status quo. If you put it in a tablet, they could do two things. I mean, it would sit, but the two parties or three parties or whatever could negotiate a settlement that you all may be agreeable to, or if it sits too long, downtown ruling takes forth.
Mayor, I'd like to make a motion that we table it. If you also choose to discuss it with them, that's fine. But I can't approve it at this time. I don't see the owner being
second. Steve, what time frame do we have to make a motion on this?
Tabling.
What's our
60 days, I believe.
What's 60 days from now? Or from the time it'll be
when it was submitted to us. Planning Commission.
Didn't talk.
When is it submitted to us?
I didn't see it till Friday in my packet.
No, it doesn't. It is when it's
It's when the city gets it, right?
Yeah.
Or when it
It's
passes
transmitted from downtown
down to us, yeah.
to us. We don't have any choice in that matter.
Yeah.
And we typically get them on the very next docket.
Hey Ray, in your motion, what do you think's driving it? Like, do you think? I mean, they've had a year to talk. What do you think an extra 40 days is going to do?
Just giving them the opportunity.
Let me stop just a second. We have a motion, so we have a Robert's Rules of Order. We have to have a motion or a second before we discuss, or it dies for lack of a second.
Point of order, Mayor. I would like to put the motion, the resolution
on the table,
the agenda item. So if we could first have a motion for first reading by title only, and pass that so that I can read it, then Commissioner Perkins, Councilman Perkins, your motion would be appropriate
so
at that point.
So to follow rule of order, we would have to have Councilman Perkins rescind his motion so we could do the other motion.
I'm confused.
All right, I'm going to rescind my motion. I'd like to make a motion that we deny this.
Okay, we're not following.
You can do that. Okay, right.
But what he's saying is we have to read it.
But I'm just.
We need to have,
The motion on the table.
we need to read the resolution. And we can either do that by title only, or I can read every word of this thing. That's the two choices you've got.
Could we say, make a motion to deny this by title only?
No.
It has, you don't have anything on the floor to make a motion to. Maybe you're not following.
And all I'm asking is to put it on the floor.
I think
And
Somebody else.
just-
I
think it's.
I just withdrew my motion.
The question is, I make a motion for first reading of title only.
Right.
By title.
By title only.
Okay.
Not for approval or denial. You're just making a motion to read it by title
Putting
only
it on
so we
the
can talk
floor
about
for
it.
discussion and possible motions later.
Yeah, I think
So
confusion is.
I'll make a motion for first reading by title only.
Second.
Okay, we have a second.
Now we
Any
can talk
dis-
about it.
Any discussion?
Yes, I have a discussion, real quickly. Discussion on that would be this, as I'm hearing it, what was explained to me. Please walk me through this. So if we approve to read this by title only, we are in fact approving this very thing.
No.
No, you're not. You're absolutely not
Okay.
approving it. That comes later. Okay? That will be the discussion. If you remember, I read the title
Yeah.
and then I say, Mayor, you may now entertain a motion to approve. So
Right.
moved, second.
That's
And
right.
then there's discussion on the merits of the particular resolution or ordinance before you.
Now Steve
Or
can
we
say
could just-
something. Right?
It does, but I'm just concerned that that we're about to approve the
Only approving
amendments.
Of the-
allowing me to read this by title only,
Yeah.
as opposed to making me read this word for word for word.
Yeah. Brian,
We'll be here till 10 o'clock.
Brian, my motion was just for him to read it by the name of the title, not to read the actual document.
No, I got that. I just was concerned about the wording below that. Okay.
Any other discussion? Hearing none, all in favor of putting the item on the floor for discussion, please say aye.
Aye.
Opposed? Motion is now on the floor for any motion that you would like to make or discussion thereof.
He's got to read it
Oh,
first.
sorry, Scott.
Resolution
By title,
691,
right?
Series 2022, a resolution relating to the approval of binding element amendments as transmitted from the Louisville Metro Planning Commission for the following development project drive-through binding element amendments, J-Town docket number 21-0007. That concludes first reading. Mayor, you may now entertain a motion to the merits of this resolution.
Now, you can either have discussion or the four choices of the, that are before you on approval, denial, table, or allow the planning commission's ruling to carry forth.
I make a motion to deny.
Second,
Any further discussion?
yes. I want to say a few things about, because I've listened a lot to this tonight. I'm not in favor of tabling, because I think we've heard enough from all parties involved. And I don't think it needs to be put off any longer. Even Councilman Bloom hit on the point that they've had a year to talk about it and have made no progress. And I will say that this council has historically been conservative, and we haven't always agreed with the planning commission downtown. And when the planning commission comes back with something that we agree upon, my first thought is maybe I need to look at it a little harder. But this time, I think the planning commission got it right. I think that we need to stay with that. And the reasons are, and I don't agree with a statement that was basically made. It was basically, if I was paraphrase it, the onus should not be on the residents to prove that they have been harmed or will be harmed. I think that the burden of proof is going to have to be on the property owner who's wanting to change the binding elements. They need to prove that the residents would benefit and not be harmed from it. I will also say that, the residents, that they elect us to be their voice in Jefferson Town. We are their advocates, and what's at issue here, and I've heard several things said, this is what's at issue, and this is what it's issue, whether it's drive-through restaurants or fast food restaurants. I think it's a bigger issue. The issue is this: binding elements are an integral part and important when it comes to negotiation and compromise between businesses in the city, or residents and businesses in the city. And so to me, what this comes down to is the main issue is, does this council respect binding elements? We always have. We've always installed them or still into properties. And we've always set buffer zones, whether it's the evergreens of trees or bushes, et cetera. And we have never, not one time have we ever looked at that and said, okay, now the trees or the bushes have matured, so we're going to reduce these other binding elements. We've never done that. We've never had it brought to us that way. So I think, to conclude this, does this council respect binding elements? I think the answer is yes. And I think that we have to champion the cause of the residents on this one. I would say the same thing if the residents were being unfair to a business. I don't think that's the case. Thank you, Mayor.
Okay. Any other comments?
Can you explain again what yay and nay?
Yeah, so the motion was for denial, so if you vote yes.
If you, Schuyler, go ahead.
If you vote, the motion that has been seconded and is before the council is a motion to deny. If the vote is in favor of that motion, in other words, you vote yes, and the majority is with that, then it's denied.
Which means the binding elements stay as written.
Yes.
Vote yes to
Previously.
keep the binding element.
All you have to
As
say
is.
is all in favor.
If you vote no, you're killing the motion.
So
You're voting yes.
A yes vote
Leave it
means
the
no.
same.
yes.
To the-
Yes vote means what?
It's
no.
well, the easiest thing is a yes vote means the binding elements stay as
Stay in
is.
place.
Yeah.
Any further discussion?
No, sir.
Bill?
Want me to call the roll?
Yes, please.
Okay. Councilwoman Ware,
It's yes to deny.
Yes.
Correct.
Okay, yes.
Councilwoman Pike,
Yes.
Councilman Ray Perkins,
Yes.
Councilman Abrams,
Yes.
Councilman Hall,
Yes.
Councilman Powell,
Yes.
Councilman Gersani,
Yes.
Councilman Bloom.
Yes.
By a vote of 8-0, motion passes.
Thank you. We appreciate all the conversation tonight.
I would like to say something. We have the 3 parcels, and I don't know why, what's his name, Mr. Thurman?
Dick Thurman, yes.
Okay, I don't know why he can't work it out with you all if he wants one of his parcels, if there's something special coming in or something. I mean, I just don't get it. Why they can't work it out, and there's 3 parcels, and why he wants this changed. I just don't get that. Why he wants it changed when he doesn't have a plan certain.
Well, he's welcome to go to him again.
Yes, I guess I was confused on
And I
that.
agree with Carol on that because if y'all remember just recently the Top Golf at Oxmoor was dying and they fought it tooth and nail. And I absolutely thought that was wrong. I'm glad Top Golf's coming in. In this situation, I don't see the landowner hurt in any way, shape, or form. That's why I voted against it.
Yeah.
Thank you. Moving along. Committee reports. Vince Grisani.
No report.
Mark Bloom.
Checking. Nothing from economic development and nothing else to report.
Thank you. Pam Ware.
No report.
Carol.
Nothing from safety tonight?
Is that it? Nothing?
Nothing.
Okay. Ray.
Just real quickly, Mayor, I want to again stress that we remember our brothers in the Ukraine and what they're going through against Russia right now. They have I think they have all our 100% support. And secondly, Sunday night is the fundraiser for the tornado victims at the Jeffersonian. I believe it's 5 o'clock, Mayor. Just wanted to make that.
Yeah, I'd like to know, since you brought up, we got a table of 8. I need to know who's coming.
I said I was going.
I said, yeah, I did too.
So it was Brian, Ray.
Coming to what now?
What is it?
There's a fundraiser by the church here for the tornado victims.
To the Jeffersonian.
It's at the Jeffersonian Sunday
What is
night.
it?
What
What
is
is it? I mean, how are they fundraising?
Oh, they're selling tickets, but the city got a table because we gave them $3,000.
Oh,
You remember when they came up and testified?
right. Okay. I'll go.
Carol?
Ron said he'd go, Mayor.
Ron?
I was the first one that said it.
Okay. I'll put you on top.
Year and a half ago.
Pam? No. Who's missing? Vince?
He's not going to be there.
No, right.
All right. Tim?
As of right now, no.
Okay, so that's
But I'll
four.
let you know if things change.
Okay, well, four right now. Myself, that'd be five. So we have 3 open seats as they are right now.
What time Sunday?
I'll send you that route.
Maybe it's on
She
this.
send you that information.
I believe Tom Mabe is going to be comedy, and then they're going to have music by some choirs and things.
Yeah, that's cool. So, all right. Anything else, Ray?
No, sir.
Thank you. Brian?
Mayor, Finance has no official report. Thank you.
And Tim?
Planning and zoning has nothing to report.
Ron?
No report.
Thank you. Hearing none and having the length of time that we've had tonight, I appreciate everybody being here. I will entertain a motion from the last person that spoke besides me.
Me,
Yes.
make a motion, we adjourn.
Second.
All in favor, please say aye.
Aye.
Opposed, like sign. We are adjourned. Thank you, everybody.
Phil, I'm just opening this candy up for anybody who wants it. I'm opening all this. I bought it for 90% off. I don't understand why they can't get along. I just don't understand it.
Thank you so much. Thank you.
Here's the things that are happening, by the way.
Yeah, I got it right here. Brian, you want a candy bar?
No, you kidding? They keep getting wet right here. Right in my way.